A very good afternoon, ladies and gentlemen, joining us from across East Africa. I hope you are all doing well and having yourselves a very lovely Thursday afternoon. It is. My name is Gabriel Achaye, and I am speaking to you from the East Africa Law Society. Welcome to this very wonderful webinar session that is discussing a very pertinent issue and an issue that for most practitioners is still a question that lingers in at the backs of our mind. And our session this afternoon, can you really enforce that? Navigating the enforcement of foreign arbitral awards across East African borders. And so on behalf of the team at the Secretariat, we'd like to welcome you all for this wonderful session. Now, this afternoon, we have a very rich panel of experts that have joined us from across East Africa, and they'll be sharing with us their expertise on the different aspects relating to our subject matter of discussion. Our YouTube channel, I would also in a special way like to welcome you for our session, and thank you for joining us on time. Now, this afternoon's session, like I mentioned, has very estimable panelists, but is being moderated by a very amazing gentleman who is an attorney admitted to the bar of Tanzania mainland. He's a certified professional mediator by Mediation Training Institute, East Africa. He has over 5 years combined experience in various matters in both the private and public sectors in Tanzania, in practice areas that include among negotiation, mediation, arbitration, and litigation. He is on the role of mediators of Restore Dialogue Uganda. He has also served as board member of the Institute of Chartered Mediators and Conciliators, ICMC, since 2025, and he's now serving as vice chairperson of the board for the 2026-2027 term. He's a member of the East Africa Law Society ADR Committee 2025-27, having previously served in the Young Lawyers Committee in 2023/25. Since 2021, our moderator has volunteered as a coach and as a member in various committees at the Africa in the Mood, an organization that seeks to help unlock the potential of international commercial arbitration in East Africa and empower future African leaders with training and resources. He's also sat as a judge and arbitrator in both local and international moot competitions, including the Willem Civis International Commercial Arbitration Moot Court and the Alfred Deakin International Commercial Arbitration Moot Court competition. Now, ladies and gentlemen, our moderator has recently completed an LLM in transnational arbitration and dispute settlement, TADS LLM at Sciences Po in Paris, France. And ladies and gentlemen, at this juncture, I'd like to hand it over to our moderator for the afternoon, my good friend, my brother, Mr. David Leons Ndika. Karibu sana kaka, and I hope you are doing well where you are. Thank you, and the floor is all yours.
Thank you very much, Gabriel, for your kind introduction. Good afternoon, everyone. Thank you so much, the participants, to the panelists for joining and for being a part of this session. Special thanks to the panelists for dedicating their time to share their knowledge with us. To the participants, I hope you have a great session. And just to let you know, as the session goes on, feel free to type in your questions in the chat, or to also wait until the end of the session where we'll have a Q&A. You'll be able to ask your questions. So without further ado, I would like for us to dive into this interesting panel titled, Can You Really Enforce That? navigating the enforcement of foreign awards across East African borders. Just to set the stage, international arbitration has become a preferred mechanism for resolving complex commercial disputes, particularly in cross-border transactions where parties seek neutrality, efficiency, and certainty. Yet for many parties, obtaining a favorable award is only a part of the journey. The true test often lies in enforcement. Across East Africa, practitioners continue to navigate a complex landscape shaped by domestic arbitration laws, judicial approaches, procedural requirements, public policy considerations, and the practical realities of cross-border enforcement. Whilst the New York Convention provides an international framework, significant questions remain regarding consistency of application, judicial attitudes, enforcement timelines, and the practical steps required to convert arbitral awards into meaningful recoveries. Now, ladies and gentlemen, as part of this panel, you will hear from Professor Kenneth Wine Mutuma, who will talk about the New York Convention and the enforcement architecture of international arbitration. I understand that he will join us a bit later due to some technical issues. And for that, we are going to move on to another part of this panel, and we'll come back to Professor Mutuma's part a bit later. Another part of this panel will be public policy, the most powerful and misunderstood ground for refusing enforcement. And this session will explore one of the most frequently invoked and often misunderstood grounds for resisting enforcement of arbitral awards, which is always public policy. So to take us through this session, Professor Joseph Yav, who is the managing partner of Yav and Associates, will take us through he will take us through this session. He's also a professor of the University of Lubumbashi in DRC, and is also an active member of the East Africa Law Society. Ladies and gentlemen, I would like for you to listen attentively to Professor Yav's presentation. And Professor Yav, I warmly invite you to take over. Thank you so much.
Thank you very much, David, for that introduction. And hi, everyone. Thank you to EALS for this invitation. Thank you. As you clearly mentioned, my topic dealt with public policy, the most powerful and most misunderstood ground for refusing enforcement. And I will deal with this topic on two grounds. Based on the New York Convention, but also based on the OHADA Arbitration Act. As you know, the Congo is a member of the OHADA law, and then we follow the arbitration and the OHADA law, even if we are also a member of the New York Convention. So I will put some insights on that. But also for this reason, there are some members in the eastern part of Africa, especially Burundi, who is trying now to join the OHADA. So thank you very much for all this. Let's start. Even if the New York Convention will be covered by Professor Mutuli, and then let me start with that convention. As you know, the New York Convention, especially of 1959, especially the Article 5(2)(b), says that a court may refuse to recognize or enforce an arbitral award if enforcement would be contrary to the public policy of that country. This is the legal text. So it's simple in principle, but it is not in practice. a court may refuse to recognize or enforce an arbitral award if enforcement would be contrary to the public policy of that country. One sentence, this is the whole provision, but many litigation and many writing is concerning that simple sentence. So the drafters made this provision narrow on purpose. They knew that no state would fully open in courts to foreign awards without some protection. But the drafter did not want to create an open door for courts to refuse enforcement freely. If we refer to the travaux préparatoires, as far as the drafting history is concerned, it's clear the words public policy were chosen carefully instead of a broader phrase like national law. The reason, as you all know, is to set a high threshold. So also, with this public policy enshrined in the 1958 New York Convention, it's only the most fundamental principle of the enforcing states can justify refusal. So the principle is, the main rule is to recognize and enforce. There are only few narrow exceptions, and public policy is one of those exceptions. Let's bear in mind that it's not an open door. It is a narrow, carefully limited exception to general duty to enforce the award. There is a relevant contribution coming from one scholar in his article in his paper in 1986, and cited wordly, is from Professor Pierre Lalève, who described what he called ordre public transnational, or in French, ordre public transnational. We can translate this as truly international public policy. These are principles so fundamental to international commerce that they go beyond any single state. Professor Lalève said that international public policy works as reservation clause that allow courts to refuse effect to awards that violates core transnational values, not just domestic rules. This framework became one of the key intellectual foundations of modern enforcement doctrine. In our other legal space, where the Congo is a member, this doctrine became binding positive law. So it's enshrined in the OHADA Uniform Act on Article 26, 1E. That article lists, contrary to the shared international public law, as one of only 6 grounds to nullify an award. Article 32 of the OHADA Arbitration Act goes further. It says the executive judge may only intervene where the award is manifestly contrary to the international public policy of the OHADA state parties. So not domestic public policy, not the internal mandatory rules of any single state, but manifestly contrary to the shared international public policy of the OHADA community. The words manifestly is not just decoration. It is a legislative instruction, and as you can see, the threshold is very high. So the violation must be obvious and unmistakable. So the OHADA drafters choose the most restrictive standard available. The issue here in the eastern part of the Africa, in our region, is the definition problem. What is public policy? This is where the challenge begins. The convention names the grounds, but it gives no definition of what public policy means. The silence is both a threat and a source of great difficulty. A first step toward clarity was given in the framework of the 2002 ILHE New Delhi Resolution on Public Policy as a bar to enforcement of international arbitration awards. The ILHE identified 3 categories. First one, substantive international public policy. These are fundamental principles of substantive law. They cannot be set aside. Example, prohibition against corruption, fraud, bribery, money laundering, and so on. The second is on the procedural international public policy. The second is on procedural international public policy. These are fundamental procedural guarantee. So without this, an arbitral process has no legitimacy, due process, the right to be heard, and so on. The third one is truly international or transnational public policy. These are rules and principles recognized across all legal systems. They go beyond national borders. But within the OHADA framework, international public policy is clearly deliberately separate from the domestic mandatory rule of any individual member state. It belongs to the world community of OHADA state party. So it is a supranational standard, not a national one. So the distinction is not just theoretical. It's not theoretical. It has direct practice consequences. Let me now pass to a kind of jurisprudence standard. So what does the international standard look like in practice? I can cite some example. We have a first case when Parson and Whitmore overseas vs. Société Générale de l'Industrie du Papier, where the US Court of Appeal, Second Circuit, 1974. The enforcement may be refused only where it will violate the most basic notion of morality and justice. And this formulation remains the global standard today. A second case, I can cite is Eco-Swiss China Time Limited versus Benetton International at the European Court of Justice. It says that public policy may be invoked for truly fundamental rules, but not for every rule that carry label of public order. Because we have noticed that on the ground, states or parties just refer order public order, without giving the meaning of the public order or using that as a tactics to shield or to refuse to enforce the award. The last, I have 6 one, but let me jump. Within the OHADA framework. So it said that under OHADA arbitration, law enforcement of a foreign award is refused only where the violation of public policy is evident, real, and concrete. So here there is no theoretical, there is no abstract. So we have to have that in mind. But there is some convergence here across all those decisions, decisions. And now, so from the US to the OHADA zone, the direction is clearly the same. Public policy is a shield for the legal order's most fundamental value, not a sword for the disappointing litigants. But what is the problem within our region? The patterns problem and jurisprudential trends. I can cite that just every major jurisdiction in our region includes a public policy exception. We have it in Kenya, we have it in Tanzania, Rwanda, and Congo, and everyone. But one challenge deserves specific attention. Us as practitioners in both regions, we face it regularly. It's the coexistence of the New York Convention and the OHADA Uniform Act that has to be clarified even within during the discussion. But The last point I would like to raise is the misunderstanding that can cost our client. I would cite three misunderstandings. One is public policy is a safety valve we can always rely on. Second misunderstanding is we do not need to worry about public policy until enforcement. The third one is a mandatory rule violation is a public policy violation. So to conclude, let me affirm that across East Africa, and I can add even OHADA zone, we are building arbitration system that international commercial community must be able to trust. And trust in this context means predictability. It means that an investor, a lender, or a commercial counterparty, whether in Europe, in America, or in Africa, can reasonably expect that an arbitral award rendered through a fair process will be given effect at the end of a reasonable enforcement proceeding. Public policy is not the enemy of that trust. And Professor Lalif was clearly state that we call it's an eviction function. It's a reserve clause that intervene only when the value of the international community of commerce are truly at stake. Let me pause there, and then I will come back if there is any question for clarification, and if after discussion with other panelists. Thank you very much.
Thank you very much, Professor Yav. What you said just at the beginning of your speech, that the statement is simple in principle but difficult in practice. That is something that has been going on in my mind, considering all the challenges that we face due to public policy considerations. And thank you for your insights. And now I would like to move on to the next panelist. And the next panelist is Mr. Claver Nigarura, who is the chair of the Energy Law Committee of the East Africa Law Society. And Mr. Claver will share with us, will talk about the fact that winning the award is easy, finding the money is hard, asset tracing and recovery strategies. So this part will focus on the practical realities that arise after an award has been obtained, and it will include asset tracing techniques, interim protective measures, freezing orders, third-party disclosure mechanisms, and so much more, especially considering multiple jurisdictions in complex commercial disputes. Mr. Claver Nigarura, you are very welcome to take over the floor.
Thank you very much, David. Thanks, colleagues. Thank you to the ELS for the invitation. Do you hear me very well?
Yes, yes, Mr. Claver, we can hear you.
That's perfect. So my presentation, if I can call it a presentation, I will deal with the asset tracing and the recovery, because in our judgments, it's just a paper until you get the money. So I try to look at practical strategies for tracing and recovering assets in complex commercial disputes and when it involves many jurisdictions. The question number one is why the enforcement gaps? why is it difficult to enforce awards in this context? How is it different obtaining an award and getting the money back? Getting an award, the rules are very clear because they are based on the rules of the arbitration center, and the success is measured on the face of the award. But recovering money, it implies many jurisdictions. It implies assets located in different jurisdictions with the different legal systems. You can understand even in the East Africa that we have Rwanda law, we have a common law, we have a civil law, and also the recovery is time sensitive because at the moment the claim is filed, no one knows that the one party cannot dissipate the assets. And also in this context, success is measured on cash, on real cash actually collected. So one thing is to get a very good award with a very good argument, but also it is important to get back the money. And by experience, I'm lucky that I am in a room of lawyers. I can be sure that some of us, some of you have so many files where you got a very good awards, let's call them good awards, but you have not been able to recover cash for your clients. So what are the main challenges in recovering money in the African context, in the East African context? So I mentioned like 4. One, it is the trust structures and the nominees. You are in the business in the East Africa, you know that some people, some companies, some assets may be under the name of nominees. The assets may be under the name of family members. Of course, I'm not blaming advisors, but sometimes some advisors may be also involved in some case of asset hiding. Also, assets can move very quickly in this context where the money is not only cash, but there is like a cryptocurrencies. The transfer of money is mobile, is internet. It's challenging to recover. That is number 2. And the third is about reciprocity gaps, because to enforce to recover assets in one jurisdiction, some countries will register foreign judgments when there is a reciprocity between the 2 countries. I can also add some political or geopolitical consideration, because, for example, if you are a foreign investor and you are enforcing on a state-owned company in a particular country, it may be difficult in reality. It is not any time, but it can be difficult. The other challenge I can mention is about our registries, like our company registries, our lender registries, our bank registries. If they are not centralized, if they are not accessible, this is a challenge, how you trace the assets, even if you have an award. So in brief, those are the 4 challenges I see. And then next, how can we try to overcome those challenges? And what may be the techniques to try to trace the assets? As the challenge is to know the true beneficial owner. Of course, some countries are now improving the types of registries, and you can now they can on demand or by law or by judgment ask for the to unmask the true owner. That's what we can look at, how we can unmask the true owner in the context of nominees and the trustees. The other technique is to engage forensic accountants or specialist agents to trace. The other technique is to ask for a decision, an order, to compel banks, lawyers, and other people to disclose even if this is protected by privileges and confidentiality. I can like name the banks, the lawyers, etc. The other technique that is at a high level is the mutual legal assistance and the coordination, and also the involvement of regulatory bodies in different countries, the cooperation between countries. Another aspect I want to talk about is the interim protective measures, the freezing order. I'm sure in different jurisdictions, being civil law, being common law, this is something that can be awarded to a party, that can be requested. Of course, some jurisdiction will apply a test to see if it can be obtained. Many countries, many jurisdictions will look at some criteria, like if it is a good agreeable case, the merits, if there is a real risk that the asset will be dissipated, if there is bad faith, or if there is a good balance between convenience and the convenience favor the freeze, and also an undertaking as to damages from the applicant. So it's not always easy to get the freezing order because of the effects of the impact it will make on the other party. But sometimes it's the only way a lawyer can ensure that the money, the award will be enforced, the money will be recovered, the asset will be brought back. So those were my ideas on this question of asset tracing, of how it is difficult, even if we have a good award. My final remarks on that, maybe the key takeaways for me is that an hour's value is only as good as the recovery plan behind it, and that as long as a claim is filed, there is a risk that assets may be moved, and a lawyer must act accordingly. It's important to use the available strategies, freezing orders, disclosures, parallel urgence actions, insolvency tools. I have not talked about a lot on that, but you can imagine also in the context of insolvency that it is not easy. And also, the last takeaway is that it's important to involve the local expertise in every jurisdiction, to help, and also having in mind that, of course, legal systems are different. The courts are differently organized, and take that into consideration, not after the award is obtained, but before lodging a claim. So thank you so much for your attention, and I'll be here to answer questions if there is any after other panelists have made the presentation. Thank you, David. Up to you, David. Thank you.
Thank you very much, Claver, for the session, and it's really important that you also highlighted different experiences and practices that are also found in East Africa, also considering that there's civil law and common law, and just like Professor Yav, you also highlighted the diverse experiences, and thank you for that. Now we would like to move to the next panelist, who is Miss Ida Juma. Miss Ida Juma will talk about courts, arbitration, and judicial attitudes, understanding enforcement trends across East Africa. And in this session, she will examine judicial approaches to the enforcement of arbitral awards across the region, including procedural fairness, emerging arbitration jurisprudence, enforcement trends, evolving relationship between national courts and arbitral tribunals. And she will also consider how such judicial attitudes influence investor confidence and the effectiveness of arbitration as a dispute resolution mechanism. Before she takes over, I would like to introduce her to you. Miss Ida Juma is a holder of a Bachelor of Laws degree from Université Lumière du Burundi. She holds also a master's degree in business law from Université Sagesse d'Afrique. She's a PhD candidate at the University of Burundi Doctoral School. She's a managing partner and head of the financial services sector at Rubert & Co. Advocates. She has 16 years experience in litigation, arbitration, and legal and financial services, gained through her involvement in numerous cases handled before all courts and tribunals in Burundi on behalf of various clients. She was a member of the National Bar Committee and of the Bar Council of the Bujumbura Mairie Bar Association, and a member of the Board of Directors of the Capital Market Regulatory Authority of Burundi. She is listed on the panel of arbitrators of the Kigali International Arbitration Center and is a member of the Board of Directors of the Women's Investment and Development Bank in Burundi, where she serves as the chair of the Audit Committee. Ladies and gentlemen, I would like to welcome Ms. Ida Juma for this next session. You're very welcome.
Good afternoon, everyone. Thanks so much, David, for the introduction. I would like to begin by expressing my sincere thanks to the ELS team for the kind invitation and for the excellent organization of this webinar. So as a moderator has just indicated, I will be addressing the enforcement of arbitration awards across East Africa. Let me frame the whole discussion around a single idea. When a commercial and investment deals break down, many parties now turn to the arbitration rather than the court. A private tribunal hears the dispute and rendered an award. Is bidding decision, yet an award is only paper because the losing side does not always pay. To turn that paper into money, the taxable part must usually approach a national court and ask it to recognize and enforce the award. This is why I have framed the title of this address, Deliberative Directive. Theme: enforcement is the true test. I can tell that an award is not a win, but enforcement is. In East Africa, an award however, is well reasoned, is worth on as much as a court's willingness to enforce it. Over the next 3 or 10 minutes, we'll follow an award through the system, the court, the arbitration framework, and above all, judicial attitude that determine whether an award ever becomes really recovery. So let's start with the mechanics, because whole journey is just 4 stages. One path from the paper to payment. Stage 1, the tribunal rendered its award. The bidding decision and the arbitration. The stage 2, recognition, the winning party files that award before national court and ask it to recognize the award as valid and enforceable in that country. Stage 3, the court tests the refusal ground. The losing side may object, but the ground for refusing award are deliberative. A defective arbitration agreement or a serious breach of due processes, for example, not simply from the tribunal got it wrong. For the stage 4 execution, once recognition The execution is once recognition, the award is enforced like a court judgment. Attaching bank account or assets, and only then does it become really recovery. All on the short lines, it is enforcement, not the award itself, that measure the true value of arbitration. Now, why enforcement matter? An award is only proper until a judge honor it. Why do I still insist so much on this one stage? Because everything before is volunteer, and everything after is depend on the state. And award is only proper until a judge honor it. Arbitration itself is private. The parties choose it and pay for it, but a private tribunal cannot seize a bank account or sends a bill if only the state can. So, enforce it is the moment where private disputes resolution meet the coercive power of the state. And is the judge, not the text of the award alone, who decided whether the power is used. Remember why businesses choose arbitration in the first place. It's for neutrality, specialist expertise, and finality, with no endless appeals. Yet, all of that value is realized or lost at the count house door. This is why enforceability, not the elegance of the award, is the really test of commercial certainty. How about the judicial attitude drive outcomes? I can say that the same law, two judges, but they are opposite results. This is the heart of my argument. So let me put it plainly. The same settings applied to the same award can produce opposite results depending only on the attitude of the judge who hears it. Picture two benches. Narrowly, it respects the finality of the award. With the templates with discipline, which is strengthens arbitration and mark outcome predictable. Exactly what commercial parties want. Now, with the other branch, a restrictive court retreats into formalism, tolerates delay, and reads the refusal grounds broadly. Under the banner of public policy or due process, is effectively re-examines the merit of the case through the back door, asking where the tribunal was right, which is not its job. The result is eroded credibility and lost commercial certainty. Some same text to mindsets two very different outcomes. That is why judicial attitude is the variable that matters most. Now, what is about the enforcement framework? I can say that there is 3 texts, 1 role, gatekeeper, not court of appeal. So what exactly does a judge really own when an award lands on the desk? 3 layers of laws, texts on top of each other. First, the New York Convention, the international treaties ratified across the region and which each state agreed to recognize and enforce arbitral awards, subject on to a short list of exceptions. Second, the national arbitration status, each country on law which turn those treaty promises into local procedure and also govern domestic awards. Third, the ordinary rules of civil procedure, the nut and the bolt and how you feel, safe and executed. Together, they define the court job, recognize the award, test the narrow refusal grounds, support execution, and policy public and due process, and keep one on distinction above all others. This role is a supervisor, not appellate. The judge guards the integrity of the process. He does not retry the dispute or second guess the result. In a word, he's the gatekeeper. He checks the ticket and he does not reply a match. So what about the enforcement in practice? Now let's move from theory to fact with 4 decisions from 2024 to 2025 that each make one practical point. Started in Tanzania, in Louis Dreyfus and Kahama oil mills, 2024, the winning party waited too long and the court held that recognition must be filed within 16 days, not 6 months. So a creditor who slips on the deadline can lose the award on timing alone. In Kenya, in Proctor and Allen View EPCO Builders 2025, the losing slide asked the court to set the award aside. The court refused, ruling that a mere error of law is not a breach of public policy. Disagreeing with the tribunal's reasoning is no license to reopen the case. In Uganda, QU and Housing Finance 2027, confirming that a foreign award is enforceable in its own right without the litigating the underlying dispute. And Watunga Review FINSA Uganda 2025, the usual attacks, bias, delay, and public policies all felt that the liberally high threshold the courts set wrote together. The message is simple. Judges are enforcing awards more deadly and tuning away merit appeals dressed up a procedure objection. This, let's go to the regional pathway. I can say that the trend is positive, but not yet uniform. This more pro-enforcement attitude is not happening by accident. It is being written into law, country by country. In Kenya, a reform bill is moving forward to curb executive court intervention and keep judges within the supervisor lane. Uganda is streamlining its arbitration procedure to cut the delay between award and enforcement. Tanzania is clarifying the path to recognition so creditors know exactly how and when to file. And Rwanda, through the Kigali International Arbitration Center, KIAC, is deliberately building itself into a regional hub, competing to be the seat where parties choose to arbitrate. And here in Burundi, reform is visible too. A new commission court of appeal with nationwide jurisdiction has been created. Arbitration and conciliation are recognized under the 2023 Civil Procedure Code, and as a part to the New York and ICCD Convention, Burundi gives foreign awards a clear route to recognition. So the honest, balanced assessment is this: the use of arbitration is rising and judicial awareness is improving, but progress is still uneven between countries and enforcement culture remain divergent. The direction of travel is clear, positive, and it seems not yet uniform. Let's be concrete about what still goes wrong and how we fix it. We can go from fiction to the way forward. The fiction is familiar to anyone who had tried to enforce an award. Delay between the nation and the execution and consistent standards, so the outcome depends on which court and which judge you draw. Procedure drag that wears down the creditor, resistance dressed up as public police, and practical hurdles once you actually try to seize assets. None of this is solvable. The way forward is equal concrete, trained and specialized judge, so arbitration cases are held by people who understand them. Keep the refusal ground narrow and resist the urge to reopen the merits. Speed up the procedure which clear timeline. Align national practice with international pro-enforcement standards and build regional coherence. So an award means the same thing in Nairobi, Kampala, Tanzania, Burundi, and Kigali. I can say that the fiction is wrong, but every point on the way forward has an answer and the right. So let me conclude by three ideas. Firstly, arbitration lives or dies at enforcement. The award is only the halfway point, and the really contest is tuning it into the payment. Second, it is the court, not the status on its own, that shape the really world's outcome. The same law can help or hinder depending on the branch. Thoughts and desires, the world talk together. Judicial culture matter as much as the legal text. Reform on paper only works when judges embrace a pro-enforcement mindset. Get those three rights and an award in East Africa become what the parties bargained for, a reliable route to recovery. And I can conclude in asking this question, in your jurisdiction, what still stop an award from becoming payment? The legal text or the judge's attitude? Thank you for your attention. I'll be glad to open the discussion and take your question. Thank you so much.
Thank you very much, Ida, for your insights. It has been very expansive to learn and see how the practice has been in the region, in Kenya, Uganda, Tanzania, Burundi, Rwanda, and how you have shared what you see the future, or rather what reforms are happening. And thank you for the question that you leave us with. Hopefully each one of us panelists and also the participants will be able to keep researching and seeing if it is the law or if it is the court or something else, and how at the end of the day can we still promote how can we still promote use of arbitration in dispute resolution across East Africa? Now moving on to the next speaker. At the beginning of this session, I told you that we'll hear from Honorable Professor Kenneth Mutuma regarding the New York Convention and the enforcement architecture of international arbitration. Unfortunately, Professor Kenneth Mutuma is still unable to actively participate on this discussion. Therefore, Mr. James Ngotho Kariuki has graciously accepted to step in on his behalf, and he will take us through this session, and he will examine the foundational principles underpinning the recognition and enforcement of foreign awards under the New York Convention. And again, he will discuss what and how the obligations imposed on national courts should be executed, the limited grounds upon which enforcement may be refused, and the interaction between international arbitration standards and domestic legal frameworks across East Africa. Throughout the session, you have heard from Professor Yav about public policy and how it's used as a ground for refusing enforcement. You have heard from Claver regarding how difficult it is to convert the award won into money, into assets, and just overall recovery strategies. You have also heard from Ms. Ida Juma concerning how the courts and their attitudes on arbitration and awards in general. So now, before we move to the future, let's talk a bit about the New York Convention, the obligations imposed to begin with, so that we can assess and see how that has been implemented, given the examples that our earlier panelists have shared. Now, before Mr. James takes over, I would like to introduce him. Mr. James Ngotho Kariuki serves as a director and treasurer of the Chartered Institute of Arbitrators, Kenya branch. He is also a director and partner at ADR Center Limited in association with Kairuki, Muigia, and Company Advocates. He is a fellow of the Chartered Institute of Arbitrators, UK, the Malaysian Institute of Arbitrators, as well as a certified professional mediator and construction adjudicator, offering a full suite of alternative dispute resolution expertise. He is an advocate of the High Court of Kenya, Commissioner for Oaths and Notary Public, previously practicing at DLA Piper Africa Kenya, IKM Advocates, in the Dispute Resolution Department. James also practices as an advocate of the Astana International Financial Center Court, AIFC. James holds an LLM in International Investment and Trade Law and has acted as counsel, adjudicator, mediator, arbitrator, and consulted in complex disputes spanning cross-border commercial and investment transactions, construction, real estate, international and domestic commercial and investment law. With over a decade of distinguished practice in ADR and dispute resolution, James has built extensive expertise and experience across domestic, regional, and international dispute resolution. James served as the chairperson of the Chartered Institute of Arbitrators Kenya branch, Young Members Group, from 2020 to 2025, and recently concluded his term as one of Africa regional representatives of the Young International Arbitration Group of the London Court of International Arbitration, LCIA. In acknowledgement of his exemplary strides in ADR, he is recognized as one of Africa's foremost dispute resolution practitioners and has been awarded Young Arbitration Practitioner of the Year at the 3rd Africa Arbitration Awards in 2022, as well as named among the Business Daily Kenya Top 40 Under 40 Men in 2023. We are very pleased to have you, Mr. James Ngotho Kariuki. And ladies and gentlemen, please welcome Mr. James Ngotho Kariuki for this session.
I hope you can all see and hear me.
Yes, we can see you and hear you.
Fantastic. Thank you very much, David, for that introduction. I am very grateful. I haven't had the benefit of listening to all the panelists who've come before me, but I greatly appreciate, first of all, the opportunity. And unfortunately, this comes on the cusp of the absence of Professor Wine Mutuma. However, I've made an internal commitment to deliver on his mandate as efficiently as I can, and I hope it imparts upon each and every attendee accordingly. So once again, thank you very much. And as David has mentioned, I will swiftly proceed to discuss ideally the architecture of enforcement of international arbitration disputes. And primarily, as David and other speakers have mentioned, this is hinged on the New York Convention. Now, that has been mentioned a lot in this conversation from what I've heard and from what I have been told. And I think it's important as a starting point to set out what exactly is this convention? Why are we subscribing to it? And what are the effects of this convention on the East African regime? So for starters, I would like to first of all point out that the full name of the New York Convention, if this has not been mentioned before, is the Convention on the Recognition and Enforcement of Foreign Arbitral Awards. So this was adopted as a UN diplomat, or rather it was adopted at a UN diplomatic conference in New York. And the date of this implementation was 10th June of 1958, and it came into force in 1959. So it's important to, first of all, acknowledge where this came from and how prevalent it is. And with respect to the prevalence, it's as it stands to date, over 170 contracting states have signed and acceded to the New York Convention. And this includes all the major East African jurisdictions relevant to this panel. That's Kenya, Uganda, Tanzania, and Rwanda. As for Kenya, we acceded this particular convention on the 10th of February of 1989. So just for context, this convention is widely regarded as one of the most successful treaties in force. And where it came from, it replaced the 1923 Geneva Protocol and the 1927 Geneva Protocol, which required a form of double executor. And basically, it was technically unworkable, especially when it came to enforcement in multiple jurisdictions. So ideally, when we talk about the core architecture of international recognition and enforcement of international awards, we are looking at Article 2, which speaks to arbitration agreements, as well as Article 3, which speaks to the obligation to recognize and enforce arbitral agreements across jurisdictions, and Article 4, which talks about the documents required to found an application, and Article 5, which talks about the exclusive and exhaustive grounds of which enforcement may be refused. Lastly, Article 6, although it may come relevant depending on what we're discussing, but that also speaks to the state of enforcement where a set-aside action, and by set-aside I mean set-aside of an arbitral award, is pending at the seat. So one thing, and I believe it has already been discussed, is the New York Convention does not operate in isolation. We also have to recognize the UNCITRAL model law, which created the predictability and universality of arbitration legislation. So if you'll notice, and if you refer to, if you lift any arbitration piece of legislation, and by that I mean any local act or law that has been enacted within a jurisdiction with respect to arbitration and arbitration awards. In Kenya, we refer to the Arbitration Act of 1995, which is also inspired by the UNCITRAL model arbitral law. So you'll notice that most of the local, and by local I mean domestic legislation with respect to arbitration is modeled on the UNCITRAL model law. And the UNCITRAL model law pays cognizance, it recognizes the New York Convention with respect to the enforceability and recognition of international awards in other jurisdictions. Now, when we talk about the applicability of the New York Convention, I'm going to specifically talk about the applicability of the New York Convention in Kenya, because I believe it translates or it transposes itself into the ideal or the preferable applicability in East African jurisdictions, as far as what has transpired in case law as well as what is already envisioned and already encompassed within the law. And to start off, under the New York Convention, and this is supported by Kenyan law, a party that is usually applying for the recognition and enforcement of an international arbitral award usually bears the burden of proving the recognition of the arbitral agreement which the award arises. So basically, it's the burden of the person who's bringing in that international award to bear with respect to its enforcement in that local jurisdiction. So an arbitral award is usually recognized as binding, regardless of the state in which it is made. That is now the benefit and the pro that the New York Convention, for those who have recognized, or rather for those who are signatories, the countries who are the signatories have ascribed to. Thus, within the Kenyan jurisdiction, the Kenyan, or rather the applicable court that is responsible for dealing with the recognition and enforcement of arbitral awards is the High Court. And in Kenya, we have various regimes, just for the benefit of those who do not know. We have the lower courts, we have the small claim courts, which usually come just before the jurisdiction of the High Court. We have the Court of Appeal, and we have the Supreme Court. So it is the High Court which usually has the jurisdiction to deal with the enforcement and recognition of international awards at the first instance. So, usually on application to the High Court, a domestic award, and by a domestic award, I mean an award that is arising out of, say, a dispute between two Kenyan entities, so a domestic award, usually shall be enforced with accordance of Section 36 of the Arbitration Act. However, Section 37 of the same Act recognizes, or rather domesticates, the New York Convention. So what that means is the New York Convention is expressly referenced in the Kenyan Arbitration Act of 1995, and that makes it domestic law. So the applicability of the New York Convention in Kenya is not theoretical by dint of the application of international law, but it is also replicated within the domestic law, hence is applicable in that sense. So in addition to additionally, an international arbitration award shall usually be recognized as binding and enforced in accordance with the provision of, or the provisions of the New York Convention, or any other convention to which whichever East African country is signatory to in relation to arbitral awards. But today we're going to specify and we're going to narrow it down to the New York Convention. So any party may apply for enforcement of an arbitral award, but often the application for enforcement is made by the party in whose favor the arbitral award has been made, and the other party is obligated to reply at application. So I had mentioned Section 37 of the Arbitration Act of 1995. And as David mentioned, this also makes reference to the grounds in which a court, or rather in this case, the Kenyan court, and by extension, courts within the East African jurisdiction may refuse to recognize an arbitral award, respective of the state of origin. So at the request of the party against whom the award is sought to be invoked, the court may refuse to enforce the award if a party proves any of the following. Now, keep in mind, while this is with respect to Kenyan law, this is also derived from the UNCITRAL model law, and it is also derived from the New York Convention, and it is lifted almost verbatim, as you will see. So there are quite a few, and I'll run through them really quick because I think they're really important, and it'll create the gist of the discussion. So a party may refuse to recognize an arbitral, or rather a court may refuse to recognize an international arbitral award, regardless of the state of origin, if it proves within that domestic court, that local court, any of the following. One, that the party to the agreement was under incapacity. That's important. Two, that the party to the agreement was, or rather that the arbitral agreement was not valid under the applicable law. 3, that the proper, or rather that a proper notice of appointment of the arbitral award was not given, or that a party or otherwise the party was unable to be present at his own case. Additionally, the award does not fall within the incurably, or rather it does not fall within, or it is incurably beyond the scope of the reference to arbitration. And additionally, that the composition of the arbitral tribunal was not as per the parties' agreement, or was afoul, or rather was afoul of the law applicable to the arbitration. Keep in mind that the law applicable to the arbitration may have been in a different jurisdiction. So if it is established that that particular award is afoul of said jurisdiction, then it will not be subject to enforceability in any jurisdiction. Next, where proof is furnished that the arbitral award has not yet become binding on the parties and has been set aside or suspended on the grounds of refusal to, or rather it's possibly a ground of refusal to enforce. So if an award has been set aside in the jurisdiction in which it has arisen, then you cannot come to another jurisdiction and claim to enforce said award. I think that's very important. The next, the making of the arbitral award was induced or affected by fraud, bribery, corruption, or undue influence. Now, the additional aspects in which may be specialized to the Kenyan jurisdiction, but there's one very notorious aspect of which I'll delve into, which will form a substantial bit of this discussion. So in Kenya, if the High Court finds that the subject matter of the dispute is not capable of settlement through arbitration, so we have matters in which we have declared that are not arbitrable, and the matters of which they're not usually arbitrable, generally speaking. One of the most famous ones, or rather one of the most popular ones, are criminal matters. Yeah. Second, if the recognition and enforcement of the public award would be contrary to the public policy of Kenya. Now, this is a notorious aspect. Public policy is subjective to the jurisdiction in which wants to rely on said public policy. Fortunately, we have jurisprudence within Kenya that has tried to elaborate as to what public policy exactly entails, but basically it depends on what each and every jurisdiction defines as public policy. Keep in mind, this is a ground for not enforcing the international arbitral award, and it is also a ground that can be relied upon by someone who intends to set aside the arbitral award. Now, I think it was mentioned in passing, but Kenya specifically usually operates within the reciprocity principle. So what do I mean when I say that? So when Kenya signed the New York Convention, it signed it with a reciprocity reservation. So the effect of this reciprocity reservation is that it may choose to only recognize and enforce international arbitral awards from corresponding signatory states and citizens. So what that means is it'll only enforce and recognize arbitral awards from fellow signatories to the same convention. And I think that's very important because it's part of the architecture. If you want your award recognized, then you also have to subscribe to the same level of said recognition if it was to happen in your jurisdiction. So I'm going to discuss a few case law developments within our jurisdiction, which are very pertinent to the enforcement and recognition of arbitral awards here and across East Africa generally. So in Kenya until 2019, or rather 2019 going forward. So when an objection succeeds, and an objection, I mean, basically an application to set aside an arbitral award, and a determination is made that an international arbitral award is unenforceable, the applicant in that case had no cause of recourse. So I had mentioned earlier in this presentation that the court of jurisdiction of first instance within Kenya is the High Court. But then that was absolute. If whatever the High Court decides, that's what goes. However, on 6th of December 2019, the Supreme Court of Kenya, in the case of Nutu Agrovet versus Airtel Networks Limited, made a determination that an appeal may lie from the High Court to the Court of Appeal, where the High Court, or rather the High Court, or rather the Court of Appeal, it may lie in the Court of Appeal where the High Court is setting aside an arbitral award, and the arbitral award has stepped outside the grounds of the said section, and thereby made a decision so grave or so manifestly wrong that it has closed the doors to justice. Now, I may not have a bit of time to move through each and every case, but ideally, the substance of what that case meant is, in Kenya, as of the moment as we speak, still a debate as to whether the right of appeal recognized by the same Supreme Court should extend to the decision of the High Court not to recognize or enforce an arbitral award based on the grounds envisaged under our own Section 37, which mirror the grounds of Section 35, which all talk about setting aside an arbitral award. So no divide has been created between local decisions and decisions that will actually affect the enforcement and recognition of international arbitral awards. So domestic awards, international awards will be treated the same under the Kenyan legislation because no division has been made, and the recognition the recognition of international awards has already been domesticated by our own local act in Section 37, for those who may want to make reference. So what are the developments that have been made within our jurisdiction? And again, it transpires to the rest of East Africa with respect to the recognition and enforcement of international awards. So I'll mention a few cases. The first case is Glencore Grain Limited versus TSS Grain Millers Limited. This is a 2012 case. It's been quite a while, but this was pivotal. And basically what the judgment talked about was that the limitation of time, ideally the limitation period of which an award can be brought or enforced due to the court's delay in rendering a judgment, may enable an applicant to recognize and enforce an arbitral award. So basically what that means is the statute of limitations does not apply if the delay is by the court itself, the statute of limitations that applies to the local jurisdiction. Now, another case that is very pertinent, especially with respect to the recognition of international awards, is Foxtrot Ali Incorporated versus Africa with a K, Aviation Handlers Limited, and ANOR. So what this case did is the court held that a breach in the procedure of an application for recognition or enforcement of an arbitral award will warrant rectification of the procedure, but will not preclude consideration of the application on the merits. So basically, the court held that where an objector challenges that recognition and enforcement of an international arbitral award on the grounds of public policy, the court has jurisdiction to substantively, and that's the key word, interrogate the said award in order to confirm that it is consistent with Kenyan law, justice, and morality. What that means is the award, the international award, can be scrutinized substantively to make sure it aligns with the domestic law and specifically with respect to justice and morality. And the court was basically also the position that the recognition and enforcement of the award was, in that case, disapproved for the reason that the International Arbitral Tribunal imposed the arbitration upon the respondent when he was not a party to the same. So that does not align with the domestic standards that have been set. And lastly, with respect to the same case, that arbitral tribunal also disregarded issues of bribery, violation of rights, breach of fiduciary duty, and non-disclosure of material facts on the part of the applicant. And in that case, the court held that the applicant cannot benefit from its illegality. So what does this mean? It means, in general, the local law in the Kenyan case, that is also applicable, especially when it comes to the enforcement and dealing with irregularities that may have prevailed in other jurisdictions. Now, there are 2 more cases, but I'll mention one that is very important. So in the case of Tanzania National Roads Agency versus Kudan Singh Construction Limited, the court declined in this case to recognize and enforce an arbitral award on the grounds that the arbitral award was in contravention of the arbitration agreement. So what it did is it applied English law to the applicable governing law instead of the laws of Tanzania as prescribed by the parties. This was sufficient evidence on record to show that the arbitral tribunal would not have, or rather show that the arbitral would not have arrived at the same determination if it applied the laws of Tanzania. So a significant internal breach, something that cannot be subject to enforcement in a foreign jurisdiction if it is brought out. I think I have enough time to mention this last case. So the Royal Exchange PLC versus Patrick Nyaemba Tumbo, EKLR. So basically, in this particular case, the court denied recognition and enforcement of the International Arbitral Award on the grounds that the respondent was not served with the requisite arbitral process notices, pleadings, and it was therefore denied an opportunity to participate in the arbitration. The said actions were held to be in contravention of the respondent's right to fair hearing and fair administrative actions. So do not fret, all these cases will be provided to you. The reality is, and again, speaking from the Kenyan jurisdiction, we've taken a more progressive approach with respect to the recognition and the enforcement of international arbitral awards. However, it's important to note that Kenyan courts are fairly strict in scrutinizing the international arbitral awards against the provisions of Section 37 of the award and in its consonance within the Kenyan minimum thresholds that have been set out in its domestic legislation. Now, a few things that I would want to mention is, as I conclude. First, this is respect to Ida's presentation and the question that she posed at the end, which is, what is, protecting enforcement, and also ideally the obligation of courts. So as she mentioned, within the Kenyan jurisdiction, she's right. We have a more supervisory approach with respect to awards because that division between ADR, in this case, international arbitration, and the courts needs to be maintained. However, the supervision is also very akin and strict to the legislation or our domestic legislation that is in force. And the other thing that I wanted to mention was that the interaction of domestic and international recognition is ideally based on, it'll eventually be based on the legislation of both jurisdictions. So in one case, you have an international award that warrants recognition. And in the other case, you have an award coming in for the purpose of enforcement within a local jurisdiction. So does the international award meet the standards of that domestic jurisdiction? And the standards, usually, again, we tie back to the New York Convention and the UNCITRAL model laws are roughly the same. So it prevents gross irregularities coming from a foreign jurisdiction for enforcement in the Kenyan jurisdiction. Now, I have to conclude now because I am substantively out of time. I would like to take this opportunity to appreciate all the other speakers. And again, all the cases I've mentioned will be presented. And if there's any further information, then we can switch that to the plenary. And alternatively, I'll also provide my contact for further information. Thank you very much, David, and thank you very much, everyone, for being on board.
Thank you very much, James, for the substantive discussion and for taking us through a lot, really. We also appreciate your promptness and readiness to come to fill in Professor Mutuma's place. I hope he's very proud of you for your presentation as well. And yes, we would really appreciate you sharing the cases that you have cited in the chat for the participants to follow. Ida as well. There was also a participant who has requested for the cases that you cited. So please, as the session progresses, kindly share in the chat so that all participants can record that and read further if should they want to do so. Now, moving on to the next panelist, who is Miss Françoise Ingabire, and she will talk about the future of cross-border dispute resolution in East Africa. You have heard about the New York Convention, the OHADA Convention, what is expected on enforcement. You have seen the practices, you have seen some of the challenges that usually occur in enforcement of foreign awards in East Africa. You have even heard about cases. Now, let's hear about the future. Let's hear about the emerging developments that are likely to shape the future of arbitration, and specifically also to do with regional integration and East Africa's increasing prominence as a destination for international dispute resolution. To do so, I would like to introduce to you Françoise. Françoise, I would like to introduce you to who Françoise is. Françoise, first of all, Françoise is going to speak on behalf, is going to share this session, and she is a lawyer with over 10 years of experience and is based in Kigali, Rwanda. She's a senior advocate of the Rwanda Bar Association, a member of the East Africa Law Society, a certified member of the Chartered Institute of Arbitrators, a certified mediator from the University of Cape Town, and a member of the Africa Arbitration Academy, AAA. She's an arbitrator, mediator, and practicing lawyer, advising domestic and international clients on commercial disputes, arbitration, mediation, and corporate matters. Previously, she served for over 8 years as registrar of the Kigali International Arbitration Center, where she administered more than 280 arbitration and mediation proceedings, supported tribunal appointments and award scrutiny, and trained at regional and international ADR conferences organized by institutions including the ICC, IBA, East Africa Law Society, East Africa Arbitration and East Africa International Arbitration Conference, CIAB, and other leading organizations. Françoise, we are really honored to have you today, and we warmly welcome you to share on this session.
Thank you very much, David. I hope you can hear me.
Yes, we can hear you.
All right, thank you. Thank you for the presentation, and also thank you for my co-panelists and everyone who has joined this insightful session this afternoon. So my presentation will be around the future of cross-border dispute resolution in East Africa. And we've heard a lot about the New York Convention. We've heard about the public policy, how to recover hidden assets when you want to enforce the arbitral award, and also how courts deal with arbitral awards. But now my task is to take you through what I think is the future of cross-border dispute resolution. But before I start, I would just, seeing what we've just learned from my co-panelists, I just have a question. If, for example, if there is a Chinese person, an investor who wants to place some capitals in one of the East African countries, I'm sure one of the questions that his lawyer is going to ask is, if anything goes wrong, are we going to recover, or are we going to be able to enforce the award? So the answer as of now will be depends, or it may take some time, depending on all the presentations that were discussed. Moving forward, I just want to have just a discussion on what is the future. What do we have to do as practitioners, as arbitration institutions, as policymakers? What can we do in order to have our arbitral awards enforced in a very short time and also in a very easy way? Before maybe I go through the future, we can go back to how disputes used to be resolved. We used to have back in 20 or 30 years, we used to have domestic disputes, and national courts will handle them. But now, when you look at the East Africa community, the FCFTA that is in place now, we are seeing growing investment. We are seeing cross-border commerce, and you find a Ugandan investing in Rwanda, vice versa. So those are the kind of disputes that are in place now, and of course, as they require more than one jurisdiction for the award to be enforced, we also need to be prepared on what to do. For example, in Rwanda, we have an international airport that is being built, and it has over 2 billion concession with Qatar Airways as a partner. So when you look at those kind of business, those are not just simple contracts. Those are decades-long relationships between states, between state-owned enterprises, between foreign lenders. So, and you would ask yourself, if something comes up, as in terms of maybe something went wrong, you would find the disputes are huge and politically, and also usually involve a foreign a sovereign as on one side. And of course, this is going to change everything about enforcement. So also we've seen the commerce has also gone digital now. We no longer deal just by we also now have digital commerces, and it's something also that is new, and that needs to be considered when in terms of drafting our laws in our respective jurisdictions. So we no longer deal with local courts. We no longer deal with paper awards only. The question maybe we'll ask ourselves is what do we do to replace what I've just highlighted? So I prepared like 4 frontiers of change, which I believe they are the future. Or if we do that, I feel like the future we look for will be won or will be lost. But I am very positive that, of course, the future will be won. So we are now facing new categories of dispute, as I mentioned earlier. So first of all, we now have investor-state disputes. We have where treaties are being signed and concession deals loaded with arbitration clauses pointing the exceed, pointing the London, the Paris, or elsewhere, and those are all those awards are going to be enforced in back home in our respective jurisdiction. And for example, if you take maybe a company, or a company signs, for example, a 25-year-old solar deal, and then a new government changes the rule because electricity becomes unaffordable, and then the investor is also going to say that the deal was broken. And then the government is going to say that the government is going to say that it's not broken, but they did it in purpose of protecting the public. And when you look at it, neither of them, is simply wrong. But the fix is not just isn't less arbitration. It's also it's matters treaty. So as East African practitioners, I believe that we need also to sit and be able to be in the discussions in terms of, when we are drafting those contracts, when you're entering into those big contracts, we also need to be involved to be able to include everything that we feel like they are going to protect us when it comes to the enforcement of the awards. Secondly, we are facing also the infrastructure, the energy, and the sovereign debt disputes, and we are also having the dispute born from technology. As of now, banks use AI and artificial intelligence. Hospitals and everybody here, I'm sure that they use artificial intelligence in one way or another. And you would ask yourself if maybe a smart contract, executing across 3 East African countries fail, made transactions, you're going to ask yourself, who is going to be responsible? Is it the software vendor? Is it the developer? Is it the person who relied on it? So all those things that I just mentioned need to be included in our legal systems, and also, of course, our arbitration rules, for us to be able to capture everything in order to protect the awards that want to be enforced. Another frontier is that there's a rise of regional arbitration centers. So now back then we used to have our arbitration disputes being taken to Europe and the LCIA, the ICC, and EVRA, and they would have the European seat, they would have the European arbitrators, and of course at a European cost, and they will be enforced in our respective jurisdiction. But now it has now started to change, because now we have, for example, the Kigali International Arbitration Center, we have the Nairobi International Arbitration Center, we actually have now the Tanzania International Arbitration Center. Those are centers that are building reputation, especially for the Kigali International Arbitration Center has been doing amazing work. It has been ranked as the 3rd best arbitration institution in one. It's because it's the first one was Cairo, another one was I think it's AFSA from South Africa. So it was the East African Arbitration Institution to be ranked by the SOAS survey back then in 2020. So you can see that the arbitration institutions are doing a great work in terms of having a good reputation, and they are no longer dealing with actually domestic dispute. For example, at KIAC, each year every report provides information that at least 40% of the cases are international cases. They are not 60% are domestic, but 40% are international. So it is also trying to put itself on international standards by offering local expertise and at global institution standards. They have this roster, and also James Ngoto is on the panel, and also Prof also is on the panel, so they can be one of the witnesses on that. And I would just want us to think, if Nairobi, Kigali, or Dar es Salaam was if it was to become the default seat, it will be very much easier for African deals, or if even East African deals, because it will, we'll keep the expertise here, and we'll build local jurisprudence here. And of course, we'll cut costs, which is very important. And of course, the enforcement is going to be easy because the seat and assets sit within the familiar legal system. So apart from those arbitration institution rising, we also have to admit that for an arbitration center to be strong in terms of the quality of service that they provide, we also need to think of, the courts, the judicial system of, each respective country here. And because I believe that arbitration cannot survive without courts, though the courts can survive without arbitration. So for an arbitration institution to survive, or for in a smooth enforcement of an award to happen, it requires that the institutional growth goes in hand with the judicial reform. They actually need to move together to provide a positive outcome. Fast forward, we are also seeing also technology-enabled dispute resolution. And if we all remember back then when COVID came, everything was happening online. Actually, we are also having this webinar online, which is a proof that, we do not have to be in one room to have a serious conversation. But apart from those virtual hearings and, sending electronic bundles online, we also need to think of an online dispute resolution platform where, someone from Kampala versus maybe a supplier from Mombasa, when they have an e-commerce dispute or a fintech, chargeback, they will be able to file their claim without necessarily going to court. So imagine like a regional online platform under the East African community where you file your digital, case digitally, where it's managed automatically, where your evidence is stored, and the process follows one standard set of rules for small claim. I believe that it's to be fantastic. For example, in Singapore, they have adopted what they call community justice and tribunals system, where it operates by the state courts, and it allows citizens to resolve everyday civil disputes such as small claims and employment issues entirely online without visiting a physical courtroom. So I believe that by also taking a look at the UNICITRO technical notes on online dispute resolution, we can actually build something for the East Africa. And I believe that also artificial intelligence will also assist us here in terms of document review, asset tracing, and increasingly also in predicting outcomes from historical, case data. And the last of the frontier that I prepared is the harmonization across the region. So when Prof. Joseph started his presentation, he actually mentioned that it's very difficult for every jurisdiction to have a definition of what is the public policy, and it's actually one of the the challenges, because each and every jurisdiction in East Africa has its own ways of they have their different legal framework. And I believe that if each state is interpreting a public policy on its own, it will be very much hard for someone to enforce an award. Maybe from someone from Rwanda is going to have a hard time to enforce an award in Kenya, because maybe we might have a different perspective or definition of what is a public policy. But I believe that that is not something that can be done overnight. I think if we I think we need like a model arbitration law where mutual recognition between East African states, where if one shared understanding of public policy, and if we achieve this, I think any award can be recognized in Kenya and be enforced in Kampala or Kigali, which without having any problem. So as I wrap up, I just want to ask all to think about what can we do. I think as practitioners, I believe that the future begins at the drafting table. When you're drafting that arbitration clause, what do you put in that arbitration clause? Because I believe that it started, the future begins at this drafting table, not at the enforcement hearing, because after all, when you reach a stage of enforcement, then that means, you're at the end of the dispute. So we need to draft arbitration clauses that, with considering the enforcement as the first consideration. We need to also draft those clauses considering the seat. How are you choosing your seat of arbitration? What do you consider? And how are the courts, how is the judicial system of that seat that you're choosing? And as arbitrators and institutions, I think arbitration institutions need to invest in transparent and diverse and well-trained rosters, in speed, and of course in real online dispute resolution and AI governance infrastructure. For example, the Kigali International Arbitration Center has an online platform where you can file your claim, you can follow up, you can track your case. And I believe that this is going, if all the institutions within our respective jurisdictions adopted that, I feel like it's something that can help each and every user in terms of access to justice. And for the judiciary, we hope for an arbitration-friendly bench that isn't that rubber stamps every award, but that bench that reviews narrowly and resists on reopening on the merits of the award. Like also who interprets the public policy in its true international sense, and having a court which is arbitration friendly, as I mentioned, will help us, of course, in terms of enforcement of our respective awards. And to the policymakers, of course, to harmonize deliberately, as I mentioned. And as I close, I believe that even though we have the new convention, yes, it is there and has been doing a tremendous work, but I believe that also better clauses, strong centers, and braver harmonization of laws, and also smarter technology, and also courts that understand arbitration. I believe that if we are able to do that, besides of having the New York Convention, we have those better clauses. We have, the strong centers. The laws are harmonized. We have technology. I think the awards might be enforced in an easy way. So thank you very much. I think I tried to wrap up quickly. Yeah, that was the end of my presentation. Thank you.
Thank you very much, Françoise. We really appreciate your insights, and thank you for showing us the developments across the region. And also really thank you for the reminder that the future of arbitration actually starts from the drafting table. So it's a call for all of us lawyers here on this session to ensure that when drafting, we think about what kind of arbitration we're envisioning, and also consider the changes that are happening in our world, and does what you're drafting really anticipate some of the developments that are happening in the region, and will carefully protect your client or this potential future party in an arbitration. So thank you very much, Francoise. And now to the participants, thank you so much for staying until this moment. We are aware that we're slightly beyond the allocated time, but we would like to have the panelists address the questions that you had. And so please feel free to type in the questions. But so far, the question I see in the Q&A chat box is from Michael. It's not really a question. He was saying that he appreciated Ida's presentation and emphasis on the benefits and of recognition and enforcement. And he is asking to have the material and list of invaluable cases that you have cited, Ida. So please, Ida, if you can share the cases on the chat, just like James has done, that would be really appreciated so that the participants can follow. I don't know if there's any other question from the attendees. Well, if there's no other question before we go quickly, I would just ask Francoise, what do you think of what some people have dubbed as multiplicity of international arbitration centers? For example, including the ones you have mentioned in the region, and there's many others in one country, 3 or 4 within East Africa. Do you think that is effective, or do you think we need to come together first country-wise and regionally as well in East Africa? Or do you think the idea of just choosing a seat would be, like a uniform seat, would be feasible, or what are your thoughts?
Thank you very much, David. I don't find any problem having multiple arbitration centers, and I believe that each country is actually trying to be the center of the seat or the center of arbitration practice. But what maybe I can mention is that I think I also mentioned that is the harmonization of some of the international standards. Because if we are in East Africa, I believe that if I, as an investor, need to invest something in, for example, in Rwanda, and I need to recover something from Kenya, though there are different institutions, I know that I'm going to have the enforcement is going to be smooth, and I will not have any for example, any problem in terms of enforcement, as long as everybody or each country follows the same standards. I don't find any problem having different arbitration institutions.
Thank you very much. Given that there's no further questions from the audience, I would like to see if the panelists have any concluding remarks to share. If they can share within 30 seconds, you are most welcome. James, do you have any concluding remarks? Or Professor Yav? Ida? Okay, we see Professor Kenneth Mutuma. Is there something you wanted to say?
No, I just wanted to thank you very much, David, for the moderation, but also to thank by extension James, who had stood in for me at the last, very last minute. I just really wanted to say a very, very big thank you to him. And I know we are in familiar territory. I heard a lot about what Francois was speaking. I think the question mainly on multiplicity of arbitration center is often answered not by fewer centers, but more cooperation between the centers. Francois, I think we've had this discussion in the past. I think what we've been often asking, very much in line with the CFTA's thinking, is how to promote greater collaboration, for example, between AFSA in South Africa, KIAC, Cairo, and so forth. But I do have to say that cooperation is key because it then establishes best practice. KIAC has been doing an excellent job when it comes to best practices when we are looking at the administration of references, enabling its rules to quickly catch up to what is happening internationally, and also the constitution.
Sorry, Prof, we just lost you. We can no longer hear you. I'm assuming it's... I'm assuming it's the network. Thank you very much, Prof, for being able to also jump in again last minute and speak to the
cooperation. I think should be seen even at hand, which is but thank you very much. That's my 30 seconds of appreciation. Thank you very much.
Thank you very much, Prof. James, you had something to say?
Yes, thank you very much, David, for your apt moderation. And I would just like to take this opportunity to thank each and every one of the attendees here. I've shared each and every case that I've referenced, including some additional information for anyone's reference. I will also share my contact details. If anyone has any questions beyond this webinar, which has been very, very, very instructive and informative. And lastly, just to touch on what Francois pointed out with respect to the multiplicity of arbitral institutions, as Professor Mutuma has pointed out, it's indeed all about cooperation. And additionally, it's also about recognizing the cooperation has to be synergetic in a sense that we, not just as East Africa, but also as a continent, but let's focus on East Africa, need a certain degree of coherence with respect to, say, our legislative regimes. And for international, or rather for regional institutes to properly blend, then there has to be an intentional effort, not just on an institutional level, but also on a practitioner level. I've had the benefit of arbitrating in Rwanda, Tanzania, Uganda as well, and the coherence aspect of basically integrating our own expertise as a region, and usually it depends. either in commercial arbitration or in investment arbitration, is very critical to protect our regional interests, as we are very, 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 very culturally ingrained. So for our voice to be heard, no problem with, I agree with Francois, no problem with as many institutions as possible. But at the end of the day, we need to focus on how we can turn this region in Africa, because we are an investment hub in terms of investors coming here to properly take advantage of that opportunity, but not just take advantage for the sake of the investors, but also take advantage to protect our own interests as a region. So I will leave it at that, and I'd like to thank my co-panelists as well. Unfortunately, I haven't had the opportunity to hear from all of you, but I am certain that that opportunity will come later on. Thank you, everyone. Thank you, David. Thank you to the organizers. Thank you, ELS. And thank you to the attendees of this session. Greatly appreciated. Very good webinar.
Thank you very much, James. Really appreciate your concluding remarks. So to all the attendees, this marks the end of our session today. It has taken longer because our esteemed panelists really had a lot to share with you. So we hope you have managed to grasp as much as you can. You have really had the opportunity to understand the commercial realities of enforcement of foreign arbitral awards across East African borders and cross-border dispute resolution. And really, we hope that you will be a part of making the future of dispute resolution in East Africa much better. So thank you very much. And I wish you all a great afternoon. Thank you so much to the panelists for joining and for dedicating your time towards the end. And to the participants, thank you, and see you again in another session. Thank you very much, East Africa. Okay. Ida, you have something to say? Yes.
I would like to thank the ELS team and the moderator, but I would like to conclude for the way that we must forward. The first one is to train and specialize judges, keep procedural ground narrow, speed up procedure, and align with pro-enforcement standards, and build regional coherence in order to ensure that the enforcement is well done. Thank you.
Thank you very much, Ida, for joining and for such concluding remarks. We really thank you and all the panelists for joining. And also, it's unfortunate that the cases you cited have still not been in the chat, but maybe we'll try to see if the ELS can share with the webinar attendees, because someone had requested for them. But we really appreciate everyone, and to the East Africa Law Society, thank you for organizing this session, for bringing us together as East Africa, and for giving us this platform to continue discussing and hopefully help to shape this resolution sphere in East Africa. Have a great afternoon, everyone. Bye.